Hello everyone. Welcome to the Public International Law course, Chapter 2, Sources of International Law. In this chapter, we have a few topics that we need to talk about. These are concept of source in international law, international custom, treaties as a source of international law, general principles of law, subsidiary sources of international law, and other possible sources of international law. Let's start with the concept of source in international law. Sources of international law are not as explicit and accessible as those of municipal law. However, the internationally accepted classification of sources of international law is formulated in Article 38 of the Statute of the International Court of Justice. These sources are international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, international custom as evidence of a general practice accepted as law, the general principles of law recognized by civilized nations, subject to the provisions of Article 59, judicial decisions, and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. Let's move on to international custom. Custom is a habitual course of conduct or general practice accepted as law. Custom evolves after a long historical process culminating in its recognition by the community. Custom may be treated as a source of law if it manifests the attributes of antiquity, certainty, continuity, consistency, and uniformity. A customary rule of international law may be defined as a rule which the community of states has since long recognized as the right rule of conduct and which has the force of law. The terms custom and usage are often used as synonyms. However, one can distinguish between the two terms. Usages are habits, often repeated but conflicting. They also vary from one state to another. On the other hand, custom is self-consistent and unified. Usage represents the twilight stage of custom. Custom begins where usage ends. However, it is not necessary that a usage should precede a custom or that a usage becomes a custom. There are two requirements for a custom to be accepted as law. There should be sufficiently uniform general practice accepted as law, and the belief that such a practice is obligatory. Consequently, for a practice or usage to become a customary rule of international law, the following two factors are essential: a material fact, a psychological element. These two are often referred to as the objective and subjective elements of custom respectively. Now, we should talk about treaties as source of international law. As you all know, treaties constitute the most important source of modern international law. Addressing the needs of modern international society and keeping pace with the changes in international relations make it imperative to develop international rules. This can be accomplished only through concluding treaties among nation-states. In international society, where there is no equivalent to state legislation, international treaties are the closest to it, though not as perfect. Such treaties are similar to private law contracts. They create rights and obligations for the parties. Since treaty is contractual in nature, its being a source of law is debatable. In other words, treaties establish a special regime, international boundaries, or an international institution. They create rights and obligations for third parties. The only classes of treaties that can be treated as a source of general law are those concluded by a large number of states. These are for declaring their understanding of what the law is on a particular subject or of creating an international institution. Such treaties are the substitute in the international system for legislation, and they are conveniently referred to as lawmaking. A lawmaking treaty, however, is also subject to a critical limitation. The treaty binds only its parties. There is no treaty that binds all the states or their peoples. Nevertheless, some jurists have tried to categorize lawmaking treaties into two types. The first type are those that lay down rules of universal international law, such as the United Nations Charter, and the second type are the treaties that create general rules of international law. Such treaties have also been termed as normative treaties. Before moving on, we should quickly talk about general principles of law. The term general principles of law recognized by civilized nations in Article 38 of the Statute of the International Court of Justice is relatively vague. The phrase applies to fundamental principles of justice that have been accepted and adopted by civilized nations. It includes, though is not confined to, the principles of private law administered by municipal courts as applicable to international relations. The court can have recourse to this source if there is no convention or any clear rule of customary law in a case before it. However, there is a difficulty in identifying and evaluating the role of these principles. Article 38 of the statute does not specify whether the term refers to general principles of international law. These are recognized by civilized nations as a part of customary law in the most general sense, including principles of private international law found in most of the legal systems. Subsidiary sources of international law are also important. Article 38 of the Statute of the International Court of Justice identifies two subsidiary means for the determination of rules of law. These are judicial decisions, the teachings of the most highly qualified publicists of the various nations. Before we come to the end of this chapter, we should quickly talk about other possible sources of international law. Apart from what we just talked about, the Article 38, other sources of international law have also emerged and received a fair mention in the judgments of the courts. However, Article 38 is silent on the decisions, determinations or practices of the international organs or institutions such as the UN General Assembly and the UN Security Council, though they are increasingly becoming important in the development of international law. This could be for the reason that when this statute was drafted, the importance of these organs in lawmaking was not contemplated. So, this is the end of our program for Chapter 2 of the Public International Law course. Goodbye and see you in our next program, Chapter 3.